and I thank all the witnesses for your testimony. We'll now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. And I'd turn first to Ms. Pepez. Could Congress, in thinking about the federal exchanges that were wished for by the Obama administration, conferred by the Supreme Court, could Congress discipline that by simply blocking funding to the federal exchanges through an appropriations process?
I certainly think that's one way that this body could do that, and presuming the legislative solution didn't work in the first place, as the Supreme Court, I guess, concluded. The opinion, by the way, I have it here, the King versus Burwell majority opinion, in response to Mr. Lazarus. I don't know about the deference point. I mean, the court does at page 8 cite the Chevron doctrine. The Constitution underlies that all the way through the end of the opinion, Marbury versus Madison. And the court concludes that the text is ambiguous, which is something the dissent obviously debates, and then it says that it's resting its opinion on what Congress meant, or what the court thinks Congress meant. And I think that's the issue. I think the first line response should be, hopefully the legislation is clear enough. In this case, some would argue it was, and if it isn't, then perhaps appropriations is the next step, or an amendment to make clear what apparently some other branches found unclear.
Well, am I just imagining a happier world that a Supreme Court would have looked at the plain language in the Affordable Care Act and realized it was missing 3 words, or federal government, and wrote a decision that it doesn't include, it doesn't lawfully allow the federal government to establish an exchange, and then simply send it back to Congress for the discretion of Congress to decide whether or not to act?
It's interesting you raise that point. So the court did obviously purport to look at the text. It concluded the text was ambiguous, which is what then allowed it to go on and say, well, let's decide what we think Congress really had in mind. Interestingly, to your point, the court in that analysis relied on the prospect of state, death spirals, and asked the Solicitor General this at the argument. They said, well, why, Justice Scalia, actually, the late Justice Scalia asked this question. He said, why couldn't this work exactly as you said? It could go back to the Congress. And the Solicitor General candidly said, I don't think we could get it done that way. So this was an example of sort of realpolitik invading the court, although the opinion doesn't quite read that way, obviously.
If it just seems to be, it causes me to think about this, if the Supreme Court's involved in deep policy effect deliberations and then configuring decisions so it brings about their preferred policy result, I wonder if this Congress could just simply make our own ruling on the Constitution and ignore the court. But I want to ask you to answer that question. I'd instead turn to Mr. Blackman, because I wanted to dig a little deeper into your statement about the narrative of the Congress that was prepared to mirror the wish of the President, who said he would veto the bill if it got to his desk, but within an hour of the time that might have happened, then issued his executive edict, which was a verbatim copy of what was on the way to his desk as a proper legislative act of Congress. How would you interpret that?
So what's stunning about the Affordable Care Act is how the law has been amended by executive action. It's indeed the case that this body considered laws that would have delayed the employer mandate. This body would have considered laws that delayed the individual mandate. And rather than working with Congress, the President said, I will veto them. Now, I'll give the President some credit. The reason why he did that was he was afraid that various amendments would be attached saying, okay, if you delay the individual mandate, repeal the Medical Device Act, repeal that, repeal that. But that's part of the process, right? You don't get everything you want. So rather than risk the law being amended by the duly enacted process, the President said, I'm going to veto that, and oh, by the way, I'm going to issue an executive action that does exactly that. And by the way, this relieves senators of taking a difficult vote. Because the President takes these actions, it relieves the Congress of actually engaging in this process. And this is actually very deleterious to the rule of law, because now Congress is not even part of it. Yes, Congress has voted to repeal the ACA 60-odd times, but there were provisions that would have been actually modified to the benefit of Americans. And because of that, the President disregarded this process.
There were some times that we wanted to help him with it on both sides of the aisle. And in this case, I took the President's actions to mean to him be saying, I am the executive and the legislative branch of government, and you, Congress, don't be sticking your nose in the legislative portion that the President wanted to conduct. And so I'd just turn to Mr. Lazarus, and quickly, please, but the same question that I asked Ms. Pepez, why didn't the Supreme Court just read the ACA plainly and clearly, and send it back to this Congress and say, if you want to have federal exchanges, you're going to have to add the language to the bill?
I'm very pleased to have an opportunity to answer that question. The challengers in that case focused entirely on one four-word phrase, which you quoted. What the Supreme Court said, in agreement with the administration, is, yes, we have to look at what the text of the statute says, but we have to look at the text of the whole statute. We construe statutes, not individual words or phrases. And when we look at the overall text of the statute, there are many provisions which make it clear that you couldn't construe that one four-word phrase in a way that would make the entire statute fail. What the Chief Justice said, and I think it's very important because, again, it's an approach. It was adopted as an interpretation by the court, and it will apply to other cases. In every case, we must respect the role of the legislature and take care not to undo what it has done. Congress passed the Affordable Care Act to improve health insurance markets, not to destroy them. If at all possible, we must interpret the Act in a way that is consistent with the former and avoids the latter.
Thank you,
So
Mr.
that's the
Lazarus.
approach that the court took. It's not ignoring the Act. It's actually reading the Act as a whole.
Thank you. Chair